How are cryptocurrency and NFTs divided in a divorce? Imagine trying to split a treasure chest filled with digital coins and one-of-a-kind digital art pieces. It sounds tricky, right? When couples divorce, digital assets like cryptocurrencies and non-fungible tokens are part of the marital property. If these assets were bought or earned during the marriage, they are usually divided just like any other property. But because they exist only online, sorting them out can be more complicated. First, both spouses need to fully disclose all their digital assets. That means sharing all cryptocurrency wallets and NFT accounts, even if they think some are hidden. Since digital assets can be transferred quickly or stored on multiple platforms, experts with blockchain knowledge are often called in to verify what each person owns. Courts want to make sure everything is transparent and may put restrictions in place to prevent hiding or selling assets before the divorce is finalized. Valuing cryptocurrencies can be tough because their prices change a lot day to day. NFTs are even harder to value because each one is unique, and their market prices can fluctuate wildly. Usually, specialists with experience in digital markets are hired to come up with fair values. When it comes to dividing these assets, cryptocurrencies can be split by transferring parts of the digital currency to each spouse's wallet. This makes the division straightforward. NFTs, however, are non-fungible, meaning they cannot be split into smaller parts. So, one spouse might keep the NFT, and the other gets compensated with other marital assets like cash or property that are worth the same amount. Tax implications are also important. The IRS considers cryptocurrencies and NFTs as property. Transferring them between spouses during divorce generally doesn't trigger taxes. But if the assets are sold or liquidated to divide their value, capital gains taxes might apply if they've appreciated since they were bought. The spouse who receives the asset inherits its original tax basis, meaning future taxes could be due if they sell it later. To protect themselves, spouses should create a detailed list of all digital assets, secure their account access, change passwords if needed, and document any suspicious activity or missing information. Getting legal and financial help from professionals experienced with digital assets early on can make sure everything is handled fairly and correctly. In the end, digital assets like cryptocurrencies and NFTs are treated as marital property and divided in divorce. But because of their digital and unique nature, they requiring special steps to identify, value, and divide properly. Usually, cryptocurrencies are split by transferring parts of the digital currency, while NFTs are either kept or compensated with other assets. Sometimes, assets are sold and the proceeds divided. Each method has its own legal and financial considerations, but with proper guidance, the process can go smoothly.